My name is David Maletta. I'm a partner at Colburn Hintze Maletta. We do divorces, child custody, anything to do with marriage and the ending of the marriage. Let's talk about divorce simplified, and we're going to go into assets. Anything acquired during marriage, the basic rule is it's community property. If it's acquired prior to marriage, it's a sole and separate property. There are exceptions to that, such as an inheritance. If you inherit money, that's sole and separate. However, if you put it into a joint account, it will be considered a gift to the community. In other words, a gift to your spouse. If that is not your intent, you want to make sure that that goes not into a joint account, but into a sole and separate account in your name. Home. A home that's acquired during the marriage and with both parties on the deed is community property. In other words, if there's $100,000 in equity, chop it down the middle, 50 each. However, if it's acquired prior to marriage and both parties are not on the deed, then it's going to be a sole and separate asset. But not to worry, because we can still lay claim to at least the principal pay down, because that's used with like a joint checking account. If it's used with a joint checking account, we can claim it's community property. So we can get a principal pay down. We can get half of the principal pay down if it was acquired, even if it was acquired prior to marriage or we're not on the deed. Retirement accounts, anything that's contributed to the retirement account during the marriage is community property plus the appreciation on it. In other words, it's 50-50. Anything proceeds put into the retirement account prior to marriage are sole and separate plus the appreciation. Any money in the bank, cars, and other assets, if they're acquired during the marriage, community property. In other words, we both own them. If they're acquired prior to marriage, sole and separate. Doesn't matter whose name it's in or titled in, because it's acquired during the marriage for banks, cars, and most other assets. Let's talk about credit cards, because we're going to go into debt now. Any credit card debt acquired during the marriage is community property. We owe $10,000 in credit cards, chop it down the middle, $5,000 each. There is an exception to that. If one party uses a credit card that does not benefit the community, such as for an affair, spending money on an affair, spending money on gambling, drugs, things that don't benefit the community, we can claw that money back in a waste claim. Student loans are a little bit different. With student loans, if it's prior to marriage, sole and separate. But I'm talking student loans are acquired during marriage, anything used for tuition and books, that is sole and separate debt for whoever took out that loan. However, anything that was used for living expenses, that is going to be community property. If you have any further questions, please call us at Colburn Hintze Maletta so we can get you in here for a free consultation and I can explain everything to you in detail. Look forward to hearing from you.